Hello, hi. Welcome to this lecture on intellectual property. And what we're going to cover today for this session is an examination of IP as a subject and whether or not should it be a subject that is to be taken or chosen as an option paper as part of your undergraduate law degree program. In many programs, IP is offered as an option paper, and so frequently we want to ask the question of what IP is about. And so today in this recording, I want to cover two questions. First, to ask what is IP? What is a study of the subject about? What are the topics, for example? And more importantly, shortly afterwards, on why IP? Who is it for? And so the main aim of this recording is where I would like to be able to provide you with sufficient information to make a decision in relation to whether or not should you choose IP as an option paper. Starting with the syllabus for IP, and this is a syllabus drawn from the University of London's law program, where there are 6 main IP rights that will be covered. Now, of course, the topics would be about 8 to 9 different chapters or topics in the subject guide, but all these chapters will lead to these 6 main IP rights. The first is in relation to the law on confidential information, and that is where this law is used to protecting ideas that are confidential. And so, for example, you may think of trade secrets as an example of this area of law. And you find this to be a very useful area of law in that it allows for individuals, allows for companies to protect confidential ideas, information, trade secrets that they may possess. And even as I use this label trade secrets, straight away it may be that in your mind you could be thinking of companies that are famous for having certain trade secrets. For example, I think right now in your mind you could be thinking of perhaps a company, Coca-Cola, where they have a trade secret for the recipe for Coke, the drink. The other company that you may have in mind perhaps is that of KFC, where they have a trade secret for the recipe of their fried chicken, right? Kentucky Fried Chicken. And so clearly you can see how this area of law can be of immense value and use for companies to protecting certain vital information that in fact forms the very core of their companies. The idea of what they're selling insofar as a recipe for their drink or for their fried chicken. This might not be so much as at that level of just recipes. Confidential information can be quite wide-ranging. This can be information or idea that you may have in relation to a business that you want to commence, a collaboration or joint venture partnership with the overseas party. That can be an example of confidential information. This may also be, for example, in relation to perhaps an idea you have for a movie, a book, or a song, and at that artistic level of ideas that you may have, even way before you develop the idea, when it's just at a stage of a thought, how do we protect your thought? How do you protect your information or your idea? It's so intangible. And that's exactly what intellectual property is about, in the protection of that which is intangible, and that relevant area of law in the syllabus is the law of confidential information. Of course, very often we find that what we have in our ideas might not just remain an idea. It might then be further, fuller developed and expressed, where the idea for a book becomes a book. The idea for a movie eventually becomes a movie. And there is now where the law on copyright comes up, where copyright is in some sense an extension of the protection of the idea, but copyright does not protect the idea. Rather, it protects the expression of the idea. And so you're seeing how in this subject of intellectual property, that we are seeing different independent intellectual property rights, but yet they all work cohesively together in ensuring that we provide a seamless, continual, and in some sense a complete framework of protection for the creative pursuits, endeavors, or products of the human brain. And so what starts off as a mere idea is protected. What is then expressed into the form of a book, a movie, a song is also protected. And that is the law of copyright. Whilst many people think or perceive copyright to be a law meant only for those who are involved in an artistic work, such as in the case of a song or a drawing or a piece of art. But copyright is beyond that. In fact, it's a very practical subject or topic that many people are engaged with without them realizing it. Say, for example, even in the course of me preparing these PowerPoint slides, it may be that I want to protect the copyright of these slides. I might not want another lecturer to just photocopy or to use these slides for their lesson because they did not make the effort to prepare these slides, and this is in some sense my creative endeavor. So as a lecturer, you can see how copyright is relevant in this instance. Not just for the slides, even insofar as the lecture notes that I provide or prepare. Again, that is where I would like to rely on copyright laws for the expression of my ideas as expressed in the form of the lecture notes that we use in class. Now that's for a lecturer. At perhaps a more corporate business side of things, a marketing person perhaps who may design marketing collaterals, a brochure, a price list, a campaign, a poster, a script for advertising, the copywriting that goes behind the thing. These are again creative products that a marketing person of a company may come up with. And again, similarly, he or the company would not want a competitor to take the poster, the brochure, the advertising campaign, for instance, for use of another rival product or service. And that is where now copyright comes up to protecting one's expression of the idea. So I'm seeking to give you a wide range of different examples for you to realize that IP is a very robust subject. It's very broad and wide-ranging. It's not only meant for those who involve in art, involved in inventing, as an inventor perhaps, but beyond that, it comes right down to the ordinary man, where we all are involved or affected by intellectual property rights. And copyright is an example of that. In fact, when I say that it affects us at a personal level, as a student, in fact, I think, and I'm sure you know how this affects you. Say, for example, that you wish to photocopy a book. Would that be infringement of copyright? I know that in your mind you'll say yes, that would be, but what about this so-called defense that you could have heard of before, this defense of private use and studying? Which is true, where in many countries there's this so-called exception of private use and studying, in that you are permitted to photocopy if it's for your personal private use. It is not for commercial exploitation. So could that apply to you? Again, I know what could be in your mind. You may say, well, it could apply, but perhaps not to the entire book. It's only permitted up to a certain amount. And that is therefore part and parcel of what we'll study for this topic of copyright. How much would you be permitted to photocopy? Is it based on percentage? Is it based on the quality of the work taken? And so these are the things or the issues that we examine in this subject of intellectual property, where copyright protects the expression of an idea. The third topic is that of design right, and that is in relation now to designers who may have come up with very good, useful designs, and clearly they want to protect those designs. In this regard, you may find that there is that overlap between copyright and design right. Copyright protects artistic works, protects designs. How then would it be that we have this other regime or framework, design right, that also comes into protecting those designs? And to understand this, one would want to appreciate that if copyright were to subsist, the duration given for the protection for copyright can be quite extensive. So what you will study is that assuming that copyright arises in the UK, for example, and to some extent in many parts of the world, the duration for protection over the copyright work, over the book or the song, for example, is the life of the author plus 70 years, 70. In other words, you can well imagine that the protection that one will have over this particular copyrighted work is fairly extensive. The entire life of the author plus 70 years. Now clearly, whilst that is good for the author, for the artist, for the designer of the design right, it may not be so good to other parties. And by other parties, I'm referring to, for instance, third parties, other competitors, the public for instance, who may want to use the design. And so, surely, if we were to only protect one side or one party, the designer, it may be to the prejudice or detriment to other parties who are now inhibited, restricted, prevented from using that design. And this is especially in relation to designs that could be useful, such as designs that achieve a function. So for now, we just call it a technical functional design, where that is a design that achieves a purpose that's useful, for example. To give you an idea of what I mean by a functional design, say you take an example of, say, shoes, and where at the bottom of the shoes we have the soles. So what if now a company designed a pair of shoes with very uniquely crafted design soles that are anti-slippery? Think of Crocs, perhaps. And so you find that those are shoes that people wear because they are comfortable, because it's anti-slippery. In fact, that was the original purpose or design of Crocs, really. And so, against that background, if Crocs had now applied for a design right over the soles of their shoes, and if they are given protection of copyright over the design, which is the life of the author plus 70 years, that means to say that no other shoe company would be permitted to manufacture or make shoes along those designs because the copyright protects or belongs to Crocs. And so hence, society, the public, we are deprived of a good. We are deprived of a useful function, and other shoe manufacturers cannot make shoes of that design. And so it's not so desirable. And so the legal framework manages to make a balance or strike a balance by ensuring that they, on one hand, want to protect the designer, but yet also want to allow for the design to be freely used by others. And so what has happened is that they've now created this regime of design right and such kinds of commercial designs, for instance, today will not be protected by copyright, but rather comes under the specific or more narrow ambit of protection of design rights for the protection of designs. And that is where the protection is only available for 25 years, much lesser than 70 plus life of the author. And in so doing, what has happened is that IP has managed to strike a balance in ensuring that we protect the designer. We give him 25 years, but it's not that long because compared to copyright, 70 years. And so the moment the copyright expires, then the design is free for use to other parties. And that is where then the public, society, may benefit from those kinds of functional designs. So even as I illustrate the topics of copyright and design right, you can see how IP as a subject is, in that sense, an interesting subject with a certain degree of philosophical evaluation or analysis, in that we want to analyze or evaluate IP as a subject in whether or not, in the first place, is such a law valid in the sense of, for example, copyright. If we were to give to all designers or all artists 70 years plus life, is that something that is good for society or for the public? Or is it creating maybe now a very monopolistic situation where the artist could monopolize the entire work and hence deprive society of something beneficial? And so IP is that kind of subject that strikes a balance between the interests of inventors and creative artists on one hand, and society and public on the other hand. That balance between creating or allowing for a monopoly as opposed now to freedom of competition, on the other side to letting people to compete freely. And so it's in that sense now a very business related concept that we also want to appreciate in the course of studying this subject. Moving further now, some other topics would be the fourth on trademark, and this of course is something that we are very familiar with because we are surrounded by trademarks. And I think if you right now look around you within your room, you would see products that you use, that you have bought, that has a brand name. And so that brand name obviously is a trademark. Or it could be a logo of a product. And so two famous examples come to mind. Say one is that of Adidas, where they have a trademark over their name. It's protected. So you and I can't sell shoes using the word Adidas. But Adidas is not just a company with a trademark over their name. You know that they are also famous for another trademark, and that is the trademark over their three-striped logo. And so if you see a t-shirt, a jersey, a track suit that has three lines on it, from afar, without seeing the word Adidas, you know that that particular apparel, the sports garment, is from Adidas. It's their trademark. You see three stripes on a pair of shoes, you know that's Adidas. You don't have to go up front to look at those words on the shoes to say, oh, that's Adidas. And so from this you can imagine or appreciate how powerful trademark can be, because companies that has invested to build up their trademark, a mark that's used in trade, would want to protect that mark to prevent other people from riding on it goodwill or leveraging on the effort they've put in over how that mark had been used in their own business. Another perhaps famous trademark is that of Nike. And yes, Nike is like Adidas, but I use Nike as an example because Nike, again, does not only have a trademark over their name, Nike, but they also have a trademark over a slogan. And you know what the slogan is? Just do it. And so I am using these two examples to show you how trademark is actually a subject or a type of law that is fairly wide. Again, it's not just covering the name of a company. It does not only cover the logo of a company, it also includes as well the slogan that a company uses. And in fact, slogans are powerful. I can right now give you some examples of slogans, and I am sure you will be able to recognize the slogan and know what it's used for, as in as a mark for which particular trade or company. Take for instance now the first example, have a break. If I say to you this phrase or slogan, have a break, you will think of the chocolate Kit Kat. Have a break, have a Kit Kat. Perhaps another example would be, it's finger licking good. Again, when you hear that slogan, it's finger licking good, what trademark would you think of? That would be KFC. I could go on and on. Of course, Just Do It, Nike is the famous example. But my point is that trademarks are powerful, it's useful in that we want to use this law to protecting the marks that we use in trade, that we use to advertise, to sell, and to create brand loyalty. And it's trademark law. The next would be a related concept to trademark. It's a common law protection. It's the tort of passing off. And passing off in the normal English usage of the word is where if I were to say that I am passing off that product as mine, I am pretending that product as mine, to pass off, to make you believe, to deceive you, to misrepresent you, right? Passing off. And so this law, or this tort of passing off, is a law used to protecting goodwill that has been acquired by a particular trade, and another trader were to misuse or to misrepresent that goodwill as their own. That is where now the original owner of that goodwill will sue the rival copycat company for passing off. An example again could be in the case of Adidas, for instance, where if you were to manufacture shoes that uses a similar three-stripe logo, Adidas can sue you for infringement of trademark. That's within statute law, where we have the Trademark Act. But at the same time, they can also sue you using common law, which is the tort of passing off, where Adidas will argue that they've acquired goodwill over that logo, and if you were to use it without permission or consent, and you misrepresent to the public as if that you are Adidas, because you are selling shoes using the three stripes, when you are clearly not licensed to do so, when you are clearly not Adidas, that's where now Adidas will sue you also for passing off, because you are passing off yourself as Adidas. And so that's how passing off is a law that's also part of IP. Right now, you could be wondering or thinking, well, why do we need passing off when we already have trademark? And in fact, in my example, I did say to you that Adidas will be able to sue using not just passing off, but as it stood, the law on trademark. Now, the reason why passing off is a very useful law or topic is this. The fact is that not all marks used in trade may be registered. Not all marks used in trade could be registered. So for at least these two reasons, we are mark. Although ordinarily we protect marks used in trade via trademark laws, but sometimes it may be that nobody bothered to apply for a trademark, or maybe even that was a mark that does not fall within the Trademark Act, within the statute for protection as a trademark. And so passing off is in a way like a backup or like a supplementary law that we could use to still provide some protection if that other party were to use the mark and to misrepresent that goodwill that belong to another party. By way of examples, let's take this instance or this famous company in Hong Kong, for example, Yongke. And you know that Yongke is famous for their roast goose. I think they are no longer around, or maybe they are rebranding or something. But that's a traditional family restaurant with a renowned history, and they've used the name Yongke for many, many years. Now, I'm not too familiar with the company, and I'm not so certain whether or not did they ever apply for a trademark over that name. But that is one possible example of how being a family type business that has been around for many, many years, it could be that that company or that family who runs the business never thought of applying for a trademark. It is more so for the traditional small-time family-run business. And I use Yongke as an example. It could be any other companies where it's managed by the family, it's been around for generations, they use a particular mark to sell their products, and they never bothered to apply for a trademark for some reason or another. That happens. And so in this instance now, if a competitor were to come along and to use that name Yongge to sell rose goose. I can imagine that the original company or party would not be happy and they may want to sue. Of course, if they have a trademark, they could use trademark to sue, but what if they don't? That's where now passing off comes up, to suing now the other party, to say that you are trying to pass off yourself as mine, you are leveraging or using my goodwill that I've acquired in trade to using Yongge for rose goose, and now because you are using it, that's not accurate, that's untrue, that's a misrepresentation, and I will sue you for passing off. Now this is one example. There's this one other example for us to fully understand or at least have a better picture of passing off and how it's useful. And that would be in relation to certain marks that perhaps that was not or that cannot be registered. For instance, a color. Would you know whether can a color be applied for a trademark? Can you say, for example, now apply for a trademark over the color green and say therefore prevent other people from using green for their businesses? Logically, the answer is no. But having said that, I think that you might also be able to think up of certain companies where they are extremely famous for a particular color. So much so that becomes their so-called trademark, a mark that's associated to their trade that they are famous or distinctive for. So for example, if I were to ask you to think of jewelry and the color blue, what company would come to mind? Right, selling jewelry and the color blue. And so some of you may think of Tiffany. And that's right, Tiffany is a company that is distinctive or famous for using that Tiffany blue or very light blue turquoise kind of color to selling its products. Now, again, colors is a type of mark that many companies would want to apply a trademark over to protect, but it's not easy. Close to, maybe even impossible, because colors are colors. And we need to allow for the public, other people, businesses to be able to use colors. You cannot monopolize an idea of a color because that color is free for all to use. And so can you imagine now that if there was this other party who now comes up, a competitor, and they sell jewelry using the exact turquoise light blue color as Tiffany, would Tiffany be happy? And the answer is no. And so they would want to sue, but they can't sue in trademark because that color is not or might not be registered because it does not qualify for protection in the first place. And so therefore the backup law that they will use is the law of passing off. And so the picture which I am showing to you is that trademark and passing off, whilst both are very similar, they are also distinct separate rights. And passing off in particular is a very useful backup law, common law, that we can use to ensuring that we protect the goodwill that's acquired in trade by traders. Last but not least, the final topic within our syllabus is that of patents. And we notice that patent law is used to protecting inventions. And so if you've invented, say for example, a machine, a robot, an equipment, that is something that for sure you want to protect. It's not just dealing with hardware stuff where patent law comes in. It may also be where you would want to apply for a patent over products such as a medicine, a drug, a cure for AIDS. Viagra, for example, when it's first discovered or invented by Pfizer, that company. And so if you having spent time and effort to research and develop a particular drug or medicine that's very useful, sure, on one hand we want to make it available to the public to consume or to access for the benefit. Say for example, if you discovered a cure for AIDS or for cancer, but then again, if you had spent so much money In fact, large companies spend money not so much as to make the drug available for you to use for free or cheap. They want to maximize their gain or profit. How do they do so? And it's exactly now using this law of intellectual property. IP law really, in summary or as an overview for now, is really a law that allows for parties to monetize their products. And so one reason why IP is really a very interesting subject is that if you have an idea and you want to commercially exploit the idea, you want to monetize the idea, then you find that IP is extremely useful because there are different areas or aspects of intellectual property rights that you can use to monetize the idea. And so in this last topic of the syllabus of patent, what you could do is that the moment you've applied for a patent over your product, the law grants you a monopoly over that product, and no one can sell, import, manufacture, or make anything that's similar to your invention or to your product. That's where now that you can sell your product at a high price perhaps. You could set up some kind of licensing structure to license other people for a fee, right, to sell your product, and in that sense now monetize your idea. And it's really the law of patents. But again, I want to just say a bit more about patents to giving you a more broader understanding of this subject. And in fact, throughout this past 20 minutes or so, I'm sure you appreciate or realize that whilst IP can be used and has and is being used to protecting traditional mainstream intellectual property products, but it's not just confined to those things, it's expanded to protecting different things. Like in my earlier last example, where I said to you that trademark can be used now to protect perhaps colors, right? I'm not saying it can be successfully, but at least you have companies who have done so successfully. And these are the cases and things we'll examine in class. But for now, the current topic of patent, I want you to appreciate in a broad sense how it's useful to protecting inventions, where this invention in question might not be hardware or a product as such, a physical product as such, but it could be where you have invented a new method of doing something. The fact is that even a process, a way of doing something is recognized in patent law for protection. It may be, but for example, it's a new manufacturing system or method that you have, in that through using this particular method or process, your products that you develop or manufacture is more durable, maybe, right? Goes through some special chemical treatment, it goes through some special manufacturing processes, and as a result now your product is better in quality. So yes, on one hand you want to apply for a patent over that product, but I'm sure that as any good businessman, you would also want to apply for a patent over that process, because it is the process that results in the product. No point having a patent over that product when you are not, or you don't have a patent over that process. And so that's where now, again, as I said to you now, I want you to understand how or what patent law really is. It's pretty broad. In America, in fact, what has happened is that they've used patent law to protecting a method of doing business. The way in which a business is run, the business strategies, the model, the concept, the method of doing business in America has been patented. A simple example by way of illustration is the famous company, first world's online bookseller. And I'm sure you know who that is. The first world's online bookseller, that would be Amazon. And so in America years ago, they had successfully applied for a patent for how they do business. Now back then they were indeed the first company doing so, and having done so now very successfully, that they automated, they have a method of allowing for books to be promoted and sold and delivered without having to have a physical bookshop. Now, of course, right now it's very common for you and I to buy books online, to even read ebooks. But back then, right, 20 years ago perhaps, or whenever that was that Amazon first launched, it's a very unique concept. It's a very different way of doing business. It's something that was invented by Amazon. And so therein now lies how patent can be used, and in fact in America has been used successfully to protecting this particular invention, where they invented a way of doing business and is now under patent. Now, I mentioned America not because their laws are different. It's actually very similar laws to UK, to Hong Kong, to Singapore, to Malaysia even. Just that obviously the judicial standard or the application of the law in different countries are different. And so whilst many countries in the world share similar laws, and if you were to compare them, you find them to be very similar, but the application of it is different. The judicial standard used are different. And so yes, there would be some differences in American IP laws to say UK or Singapore, Hong Kong IP laws, but the key principles remain the same. And so that's where now this is a subject that allow us to not just understand how it works in UK, how IP law works in UK, but also how it applies and works in other countries in a very similar manner. And so this is part one, or the first part of my recording on what is IP. I'll come back to do a second recording, and that is to addressing now the second question of why IP. And so I hope that you enjoyed this first session, and there will be a second session dealing now with the second question, which I said I'll deal with, on why IP, and why would you want to perhaps choose IP as a subject or as an option to consider as your undergraduate law degree option paper. Thank you.